Bienvenidos a CAI Costa Rica, Congreso de Arbitraje Internacional, edición virtual del 20 al 23 de octubre. El día de hoy contaremos con la entrevista y la charla Convención de Singapur sobre mediación, facilitación del comercio internacional por medio de los métodos RAC. Esta charla cuenta con el apoyo institucional del Singapore International Mediation Centre. A continuación, nuestros panelistas. El doctor George Lin es chairman del Singapore International Mediation Centre y la doctora Andrea Hulbert, presidenta de la Comisión de Arbitraje RAC de ICC Costa Rica de Hulbert, Polo y Montero. A continuación, les cedo la palabra a doña Andrea y le doy las gracias a todos por acompañarnos. Buenos días.
Bueno, muy buenas tardes a todos. Efectivamente, hoy vamos a tener mi entrevista favorita del Congreso, que va a ser con don George Lim, que pronto se los voy a presentar. La entrevista la vamos a hacer en el idioma inglés. So, it's late in Singapore, it's the morning in Costa Rica. Good afternoon, George, and thank you again for being with us today in one of our main interviews of the 11th Conference on International Arbitration organized by ICC Costa Rica. Today, we will be talking about the Singapore Convention on Mediation and its great importance in international disputes resolution. Before I start with the questions, I want to give you, George, the time to introduce yourself to the audience in America.
Hola, and thank you for inviting me to this interview. It is a great privilege. A little bit about myself. Well, I have been a practicing lawyer for 38 years now. I think it's really too long. I'm a senior counsel. We are senior counsel appointed by the Chief Justice in Singapore. And many, many years ago, I was president of the Law Society, the bar. I got involved in mediation 23 years ago. I did my training in England and in Harvard, and then I caught the mediation bug. So, you know, for many years, I've been litigating in the courts. I have been an arbitrator. I'm on the panel of the Singapore International Arbitration Centre as well. I've sat as an arbitrator. But 5 years ago, I decided, I wanted to do mediation full-time. So for the past 5 years, I have been doing mainly commercial mediations. I now conduct 1 or 2 cases a week. They are commercial cases, and it's very satisfying. Okay, I'm now in my mid-60s, and I found that this is something which I want to do, and because you see the benefit for the parties when they resolve their disputes themselves.
Thank you, George. Yeah, definitely. I think that is the best, probably the best way of practice law, instead of being in disputes, mediating and resolving with the parties. So, George, the negotiations that took place inside the ancestral working group number 2, how was the experience to finally achieve the Singapore Convention?
All right. It was a fantastic experience. Okay. In the year 2014, UNCITRAL, which is the United Nations body which promotes world trade, decided to form a working group comprising 50 countries to look into the possibility of having a convention on mediation to enforce international mediated settlements globally. Okay, the easiest way to explain, I suppose, is the equivalent of the New York Convention for Arbitration, right? Which happened in 1958, where if you have an arbitral award from a country, from a proper arbitral institution, you can take that award and go to another country, as long as that country is a signatory, and get it enforced, just like an order of court. So in the mediation world, we never had that. So I was very happy to hear that UNCITRAL started this working group. And we had 4 years of meetings in New York and in Vienna. And I was privileged to be part of the Singapore delegation. So there were 3 of us, and I was the mediation consultant.
Beautiful. And from your perspective, what is the content, and especially what is the main purpose of the Singapore Convention, besides having, of course, the great possibility to enforce the settlement agreements in every country?
Okay, so let me touch on enforceability, and I'll tell you of the other benefits. But you know, for most of us who are lawyers, who are arbitrators, you know, the contract is so important, right? I mean, if you are a party to a contract, you want to be able to enforce it if it comes to that. And that's why I think, you know, after the New York Convention, arbitration took off. Can you imagine no New York Convention for arbitration? No. Right? The awards cannot be enforced across the world. And so enforceability is important, although most mediators will tell you that if you conduct mediations properly and parties understand their obligations, problems with enforceability are less, okay? But in a small fraction of cases, it happens. A party which agrees to pay a certain amount of money by installments, for example, you know, at the mediation, but then 6 months later, something happens to his company, he can't pay. So what do? So when you go and ask business people, you know, and they say, is the mediated settlement enforceable? And you tell them no, they'll say, I'm not going to mediate. Okay, so enforceability is important because, you know, the sanctity of a contract and the ability to enforce, we all want that. It gives it teeth. But in addition to that, which is what you alluded to, for us who try to promote mediation in the world to companies, if you tell them not enforceable, they will not want to mediate. Okay, so it brings parties to the table. It encourages parties to mediate, and that we found is so helpful, because in the last few years, when we tell people about the convention, they become excited and they become interested in mediation.
From your perspective, and I heard that in another interview, you said that one of the very good things about the Singapore Convention and mediation is that it brings people to the table. And right. So can we say that this is also a way to promote the self-understanding of one's responsibility, and also encouraging the parties to find the solution for their own problem instead of giving the problem to a third person?
Yes, so that is the value, exactly, that's the value of mediation. It's actually about culture. It's about encouraging people to take ownership of their problems and to look for their own solutions. And it's so enriching when people are prepared and are able to do that. So coming back to the convention, you know, I told you that it brings parties to the table. And that has been our experience in Singapore. I chair the Singapore International Mediation Centre, which is a sister company of the Singapore International Arbitration Centre, SIAC. Some of your arbitrators will know of SIAC. But SIMC, we are not a profit company. We are focused on cross-border disputes. And we have been promoting mediation in Asia in particular in the last 5 years. We're very young, we're just like 5 years old. And particularly in China, in India, in South Korea, and in Japan. So 5 years ago, when we went to these communities, to these countries, people didn't know very much about mediation. I mean, India, I think they knew, China, they knew, but it never really took off, okay? But with the convention, okay, there has been so much interest in the ground. And I give you an example. India, which is a huge country, my mediator friends in India, they've been trying to get mediation off the ground. It takes a lot. But with the convention, because India signed the convention last year, Prime Minister Modi, he had a cabinet meeting, okay, 1 week before the signing of the convention, and he told his people, look, we'll sign it. And that has now trickled down. Okay, I've been to India many times on visits. And now they are talking about pre-court mediation. They are now finalizing a mediation act. And you can see that it is now being practiced a lot more. The lawyers are welcoming mediation because, you know, in India, it takes many years for you to get your court case heard. my Indian mediator friend did a mediation. She said the case was in court for many, many years, okay? And when the parties settled, they were so relieved. So for me, that is the value of mediation. It is actually a form of access to justice. And for us lawyers, you know, that's something very important. Not everybody has the ability or the resources to hire good lawyers, go to court, arbitration for many, many years. So this is another form, another way for people to resolve their disputes. And the beauty of it is that people do it themselves. They find their own solutions.
Yeah, definitely. And talking about what type of people we bring to that table, I have to tell you that here in Costa Rica, and also I can talk about Central America, we mediate very important conflicts, but basically they are related to family issues, labor, but we're not catching really commercial conflicts to come to mediation. So in your opinion, what will be the best way to promote mediation in international commercial transactions, to bring them to the table, to make them think?
I have, yeah. So I'm glad to hear that there is mediation going on in Costa Rica.
Oh yes.
you know, we are not that different in a sense. Your population is 5 million, right? Or about. Yes. It's the same in Singapore. All right, we are 5 odd million people, except we are on a small island, 700 square kilometers, and you are like 50,000 square kilometers. I think you're huge.
Exactly.
But I mean, mediation caught on in Singapore like 20 years ago. Actually, it was the courts which helped to encourage the use of mediation. And we found that, I think the experience is that in different countries, in many, many countries, if the courts promote and encourage mediation, it will catch on. And once you have a domestic market, okay, and you have good mediators who have been trained, then I think international mediation will just come on board. That is one. Yeah. There's one way. I want to venture another way because I know that Costa Rica, you are signatory to the New York Convention, right?
Yes.
You have good arbitrators like yourself.
Thank you.
You have an ICC chapter.
Yes.
So arbitration has already taken root in Costa Rica, and that means you have capable people who can actually mediate if they want to. They can arbitrate and mediate. So that was what I was doing. I was litigating, arbitrating, and mediating. And that is the trend in the world today. Okay, we find that it is not just one process, but clients and parties now want your lawyers to know the different processes, what is best for them to help them solve the problem. They are not interested in long drawn out court cases or arbitration cases, really. Maybe the lawyers are. You know, we arbitrators, we want to find out what is the law on this, what's the law on that. But for business people, they just want to solve their problem so that they can move on. And that is in our experience. So don't be surprised, but we have arbitrators who also mediate, and they tell you that, yeah, it depends on what the clients want.
I was going to exactly ask you about that, about the space for arbitrators to go and practice in mediation and bring their clients first to mediation. Because one thing that we have here in Costa Rica is that when you have a multi-tier clause, a med-arb clause, unfortunately, there are some courts that have interpreted that parties do not have to go to mediation because it belongs to the party's free will. So it seems that it's mostly in the hands of the lawyers and the arbitrators to encourage them to go to mediation. Or do you think that it should be a mandatory step before litigation?
Okay, so I'm not qualified to talk about your legal system, but I can say that in many jurisdictions around the world, at least in the common law system, the English system, courts have now interpreted multi-tiered clauses to be effective, to be valid, if it is clear. You know, if the steps are clear enough, and the obligations are clear enough. So if there is, for example, we have many model clauses which say that before you go for arbitration or before you go to court, you have to mediate, and then it has to be done within a certain time or with a particular institution. So there are enough factors to show that that is not an uncertainty, and those clauses have been held to be valid. So I think if you draft the clause well enough, you can overcome that problem. Okay. As to your question as to whether it should be mandatory, there are different schools of thought. Okay. For me personally, I would rather encourage people and ask people to go voluntarily, because if people come and want to explore settlement, half the battle is won. Yes. Right? If they come reluctantly, it's going to be a waste of time. Right? Yes. But having said that, I've done cases where people are reluctant, but in the hands of a good and skilled mediator, sometimes they find solutions. Okay, so that is also possible. So like in Singapore, we have many cases in the court system where the Court of Appeal encourages, they don't direct, but they encourage parties to try mediation. Okay, at that very late stage where one party already has a judgment. And I have mediated those cases and some of them settle. And of course, one party is not so willing, right? Because he's already got a judgment in hand. But when the court encourages you, you go. But sometimes you can still find ways to get benefit for both parties. So there is something to mandatory mediation. My personal preference is for it to be voluntary, but maybe in certain countries where people are so reluctant, maybe that's the only way to get people to come to the table.
To bring them to a table.
Yeah, I know like in Canada, I know there's mandatory mediation, and I think in some parts of Australia. The settlement rate is a bit lower. Usually in mediation, the settlement rate is about 70%. But when it's mandatory, it can go down to like 40, 50%, depending. But you can still get some success.
Yeah,
so 70%. I think it depends on your country. It depends on the culture. It depends on the people and how they see it. And the good thing about having mediation clauses or multi-tiered clauses is that when people come, they don't feel that it's a weakness, because people, when you have a dispute, you don't want to volunteer to come for mediation because it might be seen as a sign of weakness. But if there's a clause, people just come for mediation. So that's it. Or if the courts encourage you, you go for mediation. There's no loss of face. I think it's the same for Central America and Asian, right? We are all want to protect our face.
Exactly, but
that number, it's very important. It's very important.
And that number that you gave, 70% of cases that settled, that I believe that is a very important. That is a very important hook that we can use to engage people and make them come to mediation, because 70% success in resolving conflicts quickly.
Yes.
How can a mediation, a complex commercial mediation case can take to mediate? Just a sense of it.
1 day, 2 days, sometimes 3 at most. And I tell parties, what do you lose if we don't settle? 1 day, 2 days of fees and of time. But if you settle, you save so much, right? For yourselves. And in Singapore, the lawyers, when we started off with mediation, the lawyers were a bit reluctant. They were thinking whether it's going to eat into my rice bowl. But experience and history has shown that it doesn't. In fact, now the lawyers feel that it is part of the process. So we have trained lawyers, and lawyers see that. And and as I was telling you just before this interview, even before formal mediation or arbitration, we used to settle our cases ourselves, right? I would sit with the other lawyer in the bar room and we'd have a cup of coffee and we'll talk about the case. And at certain stages, what you thought was a good case turns out to be 50-50. And in those kind of situations, it might be better to settle and keep the client. If you go to court and lose the case, you lose the client. And so we have many cases where the lawyers think, it's probably better, and it's probably better for the clients. And they're grateful to you, if you help them settle.
Yeah, and definitely we compare 1 day, 2 days with 1 year, 2 years. That sounds very good for every client. Now, going to
Andrea, may I just say this?
Yeah,
sometimes even if you don't settle, all right, you don't settle the whole dispute, but the issues are crystallized. You help the parties crystallize issues, they narrow their differences, they might take less time in court or in arbitration. And so people have found it useful. But I have found the most value in when people come face to face in a mediation, in a confidential setting, and they tell each other, what my problem is, what your problem is, and why we came to this dispute. It's humanizing the process. And for me, I found that so attractive in that, because we are lawyers, we go to court, it's so formal. We are bound by precedents. We've got rules and processes and procedures. But in a mediation, you can carve out any form of solution as long as it's not illegal and the parties are willing to do so. And that is the beauty of mediation. It is. Yeah.
I'm sorry, George.
No. Go ahead. Yeah.
And
I get passionate sometimes.
Me too. And it looks like, and also with all the conflicts that we know that are going to definitely arise because of the pandemic situation around the world, mediation is definitely a card that we have to have on hand. Now, going to the government and to the Singapore Convention, what you have said, sign, ratify, and implement the convention. How to explain that to the governments to act fast and to really do what we need them to do to start doing formal mediation?
All right. So in mediation, we look at parties' interests, right? You know that. We look at the concerns of the parties. We don't look just at the positions they take. So for governments, I think you want to encourage business. And this convention encourages, the resolution of disputes quickly, efficiently, and it's good for business. Okay, and this is recognized by governments because I can tell you the Singapore Convention was signed last year in Singapore on the 7th of August. Okay, we never imagined it, We had 46 countries signing it. Never imagined it, in our wildest dreams, when we were working in the UN for 4 years, we were struggling, trying to cobble together the document, and so many objections, but we still managed it, and such a relief. If you had told me 10 countries would sign, I would be happy, but we had 46 countries. Okay, so that to me is significant. Because it shows that there is, at the ground level, at the business level, governments recognize they're not stupid, right? That's why you have 160 countries who signed the New York Convention. They know that this is an alternative form of dispute resolution. You're not forcing people, but businesses who want to take advantage of this process should be given that option. And this is what the convention does. And that's why we had 46 countries. I will also tell you that the US, China, not very good nowadays, but the US, China, and India signed the convention, okay? Yes. And that makes up more than half of the world's population. So this, for me, was another very significant factor, which shows that this is something which people want, all right? And of the 46 countries, I can tell you that because I know Costa Rica didn't sign. I'm so sad. Maybe you can help. Speak to your government. But I have a list here, okay? And I'm going to tell you, apart from the US, because in the Americas, all right? Chile signed, Colombia signed, Ecuador signed. Ecuador has ratified as well, okay? Grenada, Haiti, Honduras, Jamaica, Paraguay, Uruguay, Venezuela.
We are getting behind.
I didn't say that, okay? There's still time, not to worry.
No, we need to work on that.
And there are 10, all right, in South America, Central or South America, there are 10 countries who signed. Okay, Brazil is very interested, right? You know, we were in that different webinar, and the Brazilians are interested as well. And for you, there is an economic interest. Okay, why? I just did some Googling just now. Okay, in terms of your imports, all right, your big trading partners are the US and China. I know there are others, right? But US and China, and they are signatories. So when you have trading partners, okay, who have signed, you have countries around you who have signed, it must mean something. They must have done their sums, they must have done some calculations, and they signed the convention. Okay. Definitely. So for the benefit of your viewers, I mean, some of them will know this, signing is not enough, you have to ratify. So signing just shows that you are in support of it. So there's no problem to sign, really. Okay. And then you can have some time to get your domestic legislation in place before you ratify it, and then it becomes effective for your country. Okay, and domestic legislation is not difficult because you already have the New York Convention, which means you must have an International Arbitration Act, right?
Yes.
The model law.
Yes, yes, we do.
So
the model law.
All you need is to have the equivalent for mediation, and I take it that your courts would be the competent authority. Right?
Yes.
If I have an award in Singapore, I go to your courts. If I
Yes.
want to enforce it in Costa Rica, right? So in the same way, the courts will take the mediated settlement, see whether it conforms with the terms in the convention, and decide whether or not it should be enforced in Costa Rica. So for me, it's not a difficult process. And that's why you have so many countries signing on. And you can see they are your neighboring countries. They are not big, right? Some of them are not big as well.
Oh.
So go to your government, speak to your ministers. I mean, I know right now it's been difficult because of COVID-19. I mean, the world has been turned upside down, and it's difficult to get governments to pay attention, to give attention to this, and rightfully so, right? They just have to handle the pandemic. But post-COVID, I think governments will come around to signing and ratifying. So it will take some time, but it will come. It will come about.
No, and I have
because there's value in this. Yeah.
I have to give you a good news. Like, we have an important group of people that are interested in mediation. So we're definitely going to work to encourage Costa Rica and the rest of the countries to actually sign and ratify the convention because of everything we have talked in this interview, which is so, so important. We are convinced that it is necessary for the country, and especially in these moments. I guess this is the right moment. It's difficult to put it into the agenda, but this is the moment we need to start talking about mediation and a fast way to solve conflict between commercial transactions and allow the merchants to continue doing their businesses in a friendly way without avoiding conflict. So time is of the essence, but I need to make you one more question, and I wanted to talk about the professionalism of the mediator. It is extremely important for the parties to have a professional mediator for the success of the procedure. So what type of preparation would you recommend for a mediator, and especially for us to learn international mediation, George?
All right. So I teach mediation as well. I train mediators. So before you can become an international mediator, you must become a good mediator. All right. And people ask me, what are the prerequisites? What are the characteristics of a good mediator? And I've got this thing called the 3 Ps. You know the P? 3 Ps. Okay. And I tell you, the first P stands for people skills. You need to have people skills, because in mediation, you've got to get people to talk. You've got to get people to tell you what their real concerns are and then get them to find solutions. All right. You can't be just sitting back and telling people what to do. So you need some people skills. The second P, I call it process, because in mediation, there are processes. We have private confidential sessions, we've got joint sessions, we've got, so you need to know how to use the process to help people come to a conclusion, come to an outcome. It's not just talk. There must be a solution at the end. And the third P, can you guess, Andrea?
The third P?
The third P, yeah. What's
You
the third
tell
P?
me the third P.
Okay. Yeah, I'm being interviewed. The third P is problem solving skills.
Great.
So for me, again, it's not just about talk, but the ability to guide the party so that, you know, they can find some solution which both of them can accept. So these are what I call the 3 Ps. And for very generally, if you want to be a good mediator, so you need training. And it's not just training in the classroom, but I think you need experience.
Yes.
So in Singapore, we do things like co-mediation. If you're a new mediator, you co-mediate with somebody more senior or experienced, and you learn on the job a little bit before you can do it on your own. And then for international mediation is different, all right? Because in international mediation, you have parties from different countries, different cultures, different languages sometimes. So you need to do a lot of preparation to understand the parties. And it's not always one size fits all. You know, like for example, a Chinese from mainland China, or Chinese from Singapore, or Chinese from the US, different, right?
Yes.
Yeah, so you need to understand, and you cannot just generalize, but you need to do a lot of preparation in terms of the parties and to understand their culture, and then understand how to communicate and how to build rapport with them. So for me, in a mediation, one of the most important things is to build rapport with the parties, to connect,
Yes.
so that people feel that you are actually trying to help them solve their problem. When people feel that, they open up. Okay, so find ways to be able to connect and understand the culture, understand the problems, and experience. You know, you need to do it. You can't read it from books.
So we need to practice, and then prepare very well for the mediations that we have to do. And so it has been, George, a great honor to have you here. And I would like to give you a time to give the last words, a message for us here in America.
Okay, I have 2 messages. All right, it just came to me, but one of course is for Costa Rica to sign the convention, and I think it'll be good for your people, for your businesses. And if you do need any assistance in terms of, you know, materials or resources, feel free to contact me, okay? Because I was part of the Singapore delegation, so I'm in touch with people. And so that for me is one wish, and don't wait too long. Okay.
No, okay. I want to personally thank you again. You wanted to say something else, George?
Yes, my second wish, if I have time.
I'm sorry. Yes, sure.
No, it's okay. My second wish is, you know, we are going through a very difficult time with COVID-19. And people are going to suffer. Businesses are going to suffer. Contracts are going to be broken. People will not be able to comply with their obligations, not because of their fault, but because of the situation, right? If there's a lockdown, for example, you can't. If there's no business, how are you going to pay your rent? So this is a special time. And my appeal to people is, you know, we have legal rights, right? If the other party has not complied, I could go to court, I could go to arbitration and sue the person and make him a bankrupt or whatever. But I'm making a plea for this time, for this particular period, for people to be more understanding and more compassionate, and to mediate their cases, okay, for themselves. Because I think then, you know, if we try and be more understanding and resolve the problems, in the long term, it is better for your society. As a people, you come out stronger, you come out more united because you've gone through a difficult period together. So that's my second appeal, that people try mediation, and perhaps what I would call it is use mediation as the first port of call. Try it first. If you don't succeed, you can still go and fight. You can still go and litigate or arbitrate. But try it first for the sake of our own societies.
I truly agree completely. So for all of our audience, we can see, George, that you're not only a great mediator and negotiator, but a great person. And I have to thank you. It has been a great honor for me to interview you today. And we're going to take your words and we'll be asking for help in moving the approval of the Singapore Convention, not only in Costa Rica, but as far as we can. Thank you very much, George Lim, for being here.
It's been a great pleasure, and thank you for having me today.
Thank you.
Thank you.